Ladies and gentlemen, our second speaker for the day is Mitch McKenzie, who I noted that my dear friend Bill Rimmer got a bit touchy when I said that he had been at the bar only 9 years. He was a solicitor with a lot of experience. Mitchell McKenzie was a solicitor for about over 30 years before he came to the bar. He's had a lot of experience in property law, and he will be speaking to you on avoiding off-the-plan sales summaries, right?
Oh, well, good morning. A little bit awkward because last night I was chasing up a proposed amendment to the Sale of Land Act, which is right in this very area, and I've made some inquiries with very respectable, well-known people in the property law area, including certain people at the front table and others, and quite frankly, I'm not sure what the position now is, so let me just mention it to you. I thank those who've raised it with me, but I haven't got an answer. There is currently a proposal that the Consumer Affairs Legislation Amendment Reform Act of 2010 would provide for an amendment to the Sale of Land Act on a consumer protection basis. And the proposition was that it would amend the Sale of Land Act to include a new section 9AA 1A. And that would provide that a contract for sale of a lot, referred to in subsection 1, which is a lot, a sale off the plan, must include on the front page a notice to the purchaser saying that the purchaser may be able to negotiate about the deposit, that there may be a substantial elapse of time between the date of signing the contract and the date of settlement, and that the value of the lot may change. Now, those elements are the elements that I refer to in the paper proper. And I have been, when I shot the paper out to a couple of people and said, I'm about to give this paper, what's the word on the street, as it were? And someone came back and said, 1st of September, this new notice clause thing is coming in. There may well be someone present who knows rightly or wrongly whether it's coming in. 1 September 2012. I had a note yesterday from a mate who does a fair bit of this, and he said 1 September. I've seen the submission from the Law Institute, 11 May 2011, asking that the change not come in. I'm hearing that perhaps it's bumped through to October. I'm hearing perhaps it's bumped through to 2012. My own inquiries showed that that particular act didn't include the Sale of Land Act amendments, but of course, the very sensible inquiry I had this morning was someone said, I'm about to run off a batch of contracts, I'm circulating them out to the selling agents and God knows who. They may be signed in the next week or 2 or 3, but if I need this in by 1 September, I better put them in now, because my guess is if we sell 10 or 15% before 1 September, fine, but if we sell them afterwards and the contracts are hanging out there, I better have this notice in. So I draw your attention to the fact that it was proposed. My inquiries indicate to me that it's not going to happen on 1 September, but I didn't get a proper chance to check it through thoroughly, and I know there were submissions made by the Institute to say this isn't an appropriate way to go, and it gives rise to a number of serious questions. Another view was expressed to me which said, look, if you might have to put it in, and it just says do these notices, subject to certain limits, the purchaser may negotiate with the vendor about the amount of deposit money payable. Well, not a critical disclosure. A substantial time may elapse between the day of signing and the day they become the registered proprietor. No big deal. The value of the lot may change between the day of signing and the day they become the registered proprietor. So there was one proposition that said, look, if in doubt, whack it in. Because if you don't, what's your position? Which is something of an embarrassment, because here I'm talking about avoiding sales off the plan, but my inquiries last night led me to wonder whether this has really happened. I suppose it would just be a word of warning. Check it more thoroughly than I've been able to do in my inquiries yesterday. I went to Ostley. I've had a ramble through Ostley as to up-to-date contract acts, and then Ostley as to specific acts. I looked at this specific act and it didn't seem to have the Sale of Land Act provisions in it. I looked at the Sale of Land Act, didn't see amendments. I've seen an ANSTAT printout that's got the amendments in it that someone showed me this morning. 30 June 2012. Okay, so well, the act that we were looking at was Consumer Affairs Legislation Amendment (brackets Reform close brackets) Act of 2010. That act has been passed. It did have a provision, it was proposed to have a provision for a 1 September start for those notices. It's the sort of thing someone said to me with a little bit of venom. You would have thought the Institute would have been onto this and told us if we needed to, and you'd need to know by early August, wouldn't you, if it comes in 1 September. But if it bumps through to 12 and they know, then they're not out there scaring the horses. So can't take that any further. Sounds authoritative, thank you for that comment, but protect your back. So, all right. I occasionally, when I give talks on a variety of things, mention that I've got a collection of little statements that people make where people have got it not quite right. The one that I was going to mention today is probably more than apt. It's one where somebody said to me they'd had a row with their bank about some finance, and they intended that the person who'd given them the advice and mucked them around should be hauled over the knuckles. And you sort of think, well, it's probably wrapped over the coals. No, I'm not sure, but it's clearly wrong. With this one, don't say I didn't tell you. There's something hanging around out there. I think it's bumped through. My preliminary inquiries were it was certainly proposed. It looked like it was going to happen, but it might have fallen over between the Labor government and the Liberal government, and maybe the Law Institute's request not to include it has been fruitful. But protect your back. So I won't actually read the paper to you. I think I'll just perhaps talk to the paper. The first thing is I've set down in that, on the first page, a list of the things to gather. And I can tell you now, I've spent some time last year dealing with trying to get people out of terms contracts, off the plan contracts, and in particular, and I make no bones about it because we've issued and we've done this and we've done that. The one that I was particularly interested in was a series of sales associated with the Pentridge development, and that took a long time. So the thing about that I note is it was old form contract, and before certain of the cases came through, and there was a great deal of toing and froing. We had some walk-away, stand-up success, certain notices, bang, gone, deposit back in full. We had other major rows about whether we should or shouldn't have been able to get out of it, and we've had certain negotiated outcomes that were quite satisfactory in a number of ways. People actually signed up. So let me just identify, if you're sitting there thinking it's going to happen to you, it has or it might. They walk in, they say, settlement's coming up. We've had letters from the vendors, solicitors saying registration is due in 3 to 5 weeks. We've got to settle. We can't get the money. The bank's refused. The finance isn't available. What are we going to do? Always the easiest thing in the world, isn't it? If they can't settle and they can't get the money, all you can do is use your best endeavours to get them out of it. No really critical issue there, but how do you do it? What are the list of things you've got to do, and how to set about it? So, if I look just at the material to be gathered, let me identify the two that I think are particularly critical, which is the plan of subdivision as included in the contract, and the plan of subdivision as included in the proposed settlement. Do the search and get the up-to-date plan, and look at the differences. because one of the significant issues arising are, have there been any material changes to the plan of subdivision? And if there have been material changes to the plan of subdivision, have you been informed about them? And if those are material changes, you are entitled to walk away. The backup to the changes in the plan of subdivision is changes to the building permit. What I'd like to stress is don't spend too much time waiting for the paperwork to come in, because you'll find they are contracts 2, 3 and 4 years old. You need the original plan of subdivision and the current proposed plan of subdivision. You need the differences. And can I just direct you to look at the version number on the surveyor's notes at the foot? You'll see version 3, version 7, version 9. Every version's a change. Every change may or may not be material. And if you can pull it apart by looking for that, you're well underway. So the other time-critical thing that I want to say to you is a lot of the remedies that you might want to avail yourself of must be taken before the registration comes through. So if you're told, get ready for settlement, sort out your finance, here's a draft statement of adjustments, the owner's corp's doing this and we're doing that, and we want our checks this way from the vendor's practitioner. And I suppose I'm pitching mainly, most of the vendor solicitors know all this stuff because they've been on the wrong end of it for a long time, but it works in reverse for vendors, of course. But when that's coming up, if you don't get your notice in before the registration comes through, under the Sale of Land Act provisions that relate to that, you are shot. Okay? So if in doubt, tell them that you're withdrawing under either of the two principal limbs that I've referred to in the paper as soon as possible. Don't wait to gather the material. Don't worry about whether there might be 6 other different bases available, because my experience has been if you don't get it in quick enough and the registration comes through while you're wondering, it'll be too late, because your statutory rights give you the right to avoid prior to registration of the plan. So if in doubt, get it in and say that you're out. Okay? So I'll now work in a more orderly fashion through the paper, which is just on the headings, by and large, the Section 32 issues. We all know that, Section 32, there it is. Section 32 isn't a continuing obligation. It's got to be right at the day that you get it. If it's right at the day you get it, well, bad luck if it's changed since. Will it have changed? Almost inevitably. They did the contracts, they did the plans, and they did the building proposals and the planning permissions back 3, 4, 5 years ago. They've since built stage 1, stage 2, stage 3, and I've had people get caught on stage 2 and have some fights about deposits in and out. But because we knew what was happening there, because there are also other family members or syndicates associated, we've walked away from stage 3 because we could see what was happening. We were a bit late in stage 2 because registration came through before certain things were done or said. So with Section 32, it's before settlement. There's no time limit problem there. Even if you get caught and the registration comes through, well, work through the Section 32 top to bottom and see if you can pull it apart. Not hard to do, but there's no update or continuing obligation, so the fact that it's wrong now doesn't matter a hoot. It's what happens later. I talk about enforceability generally. I've had a few goes at the fact that the vendor can change the place, the time, the date, the area, whatever variations they want, and quite often to their heart's content. There's been some authority on that going back to the old rocker cases and subdivisional cases earlier on. The courts have tended to say, look, if you're selling off the plan, commercially we've got to be realistic, there's got to be some flexibility, and they're not well inclined to permit you to just say, look, it's all so vague and the vendor can change whatever he likes. But I think that's still open, and there's certainly contracts I've seen which are so wide that the vendor can do, say, modify whatever they like, and it's said to be at their discretion. It's a contract. It's an agreement to agree in a lot of ways, and I think one of those might still get up. All right, I'm through to, in effect, paragraph 5 on my paper, which is the way the pressure comes on. I comment there on 9AA, deposit must be held and dealt with in a certain way. That's pre-registration, and of course the Everest case Bill has referred to. A couple of important elements to that. Hargrave saying deposits must be held in a certain manner, and what you do find is the old contracts, the developers permitted people to have deposit bonds. The critical issue with deposit bonds were that they usually say that the bond is able to be paid by direction to the vendor. So if the bond's called in, it gets paid to the vendor. If the bond gets paid to the vendor, then the deposit isn't being held as stakeholder or on trust under the Sale of Land Act provisions about holding it, the Section 27 releases that we've all mucked around with. So basically, if you've got a deposit bond situation, you're looking all right. Real prospect of getting out if it was paid by a deposit bond. But again, got to get in and do it and claim it before the registration comes through, because once the plan's registered, then those rights are lost. The second thing about that is that there is currently a fair bit of movement at the station amongst the big developers and subdividers, because they're saying we want to recast things so that deposit bonds do comply. And that will, the current proposition, just some of you will know this already, current proposition is to try and arrange for deposit bonds to be required to be called up and paid to the vendor's solicitor to be held on trust. And if that were to happen, then that won't fall foul of the Act, in the sense that it couldn't then be said that the treatment of the deposit in the contract didn't comply with the requirement, and if it didn't then fail to comply with the requirement, your right to get out is gone. It's not currently in place, but the financial instruments are being tinkered with to see if they can come into compliance. So at present, if the bond was paid 3-5 years ago before Everest, you're probably able to walk. And I can tell you now, if you write off the letter saying that's what we rely on, you'll usually get your deposit back reasonably smartly, because they're not fighting you on that. It's well accepted. But I'm not sure how much longer that'll be the case. So it's watch this space a little bit. There are some changes in process, and I think the next case, if it's more recent, and certainly if it's post-Everest, you can expect that the financial instrument that you're attacking will be a different instrument, and it might be a bit closer to compliance than the old ones. The disclosure of works to the natural surface of the land, that's always a bit interesting. There have been a couple of comments on that, and it popped up in the cases that I've referred to. Again, you're back to what was the nature of the disclosure. There is an issue about there being a continuing obligation for disclosure, and there are some issues about natural surface of the land and basement car parks and some of those issues. It's basically an engineering and a building question, worth pursuing, and it does give you some rights. There's no formal authority that I'm aware of dealing specifically with that as to an outcome, but it's certainly mentioned in Everest, and Hargraves does talk about it, but he doesn't have to decide on it. The amendments to the plan issue, 9AC, that seems to me to be the one which gives you a good opportunity. Again, no formal rights that arise, and let me just identify the two elements to that. One is the vendor, within 14 days after a requirement from the registrar, or if the vendor makes a request, advise the purchaser in writing of any proposed amendment to the plan of subdivision. So that's the first string, 9AC1, the vendor to advise. Now, I've had people, solicitors for developers, say, we have made an amendment, but we don't think it's significant, and we would like your view as to whether it's material or not material. My answer is this: you must, within 14 days after being told that it's going to happen or after making the change, advise the purchaser in writing. It's not complied with. You've seen it yourselves. Version 3, 4, 5 of the plan of subdivision, they're changing it as they modify it, as they build it, and they're doing this and doing that, changing the basement, changing the car parks, changing the pillars, modifying this or that. But the fact that they didn't tell you within the 14 days of the change, when it finally comes through for the modification to the plan, isn't enough, because you've got to get to 9AC2. The purchaser may rescind within 14 days of being advised by the vendor, under subsection 1, of an amendment to the plan which will materially affect the lot. So they should tell you within 14 days. You've got 14 days to get out. So the thing to watch out for then is, if settlement's coming up and they tell you here's the new plan and it's the final version and they're going to lock in on that, then hope to God that they haven't sent something, and they've been doing this, direct to the purchaser. Here's a list of the amendments. It's in amongst a whole lot of other stuff, and then you discover that they've actually told you, and they told you it was going to change, and your 14 days has elapsed. That's not as frequent a problem as finding that they haven't told you at all. And at present, it's not totally clear that their failure to tell you, well, I can say this, the failure to tell you doesn't of itself give rise to a right to avoid. If they tell you and it materially affects, then it does give rise to a right to avoid. And I had an argument about one particular plan where, when we checked the plan, the lot that we were buying, notwithstanding that we couldn't get it financed because the price we were paying was way ahead of what the bank would finance, and we couldn't go ahead anyway. One of those easy ones, doesn't matter. But the footprint was increased by something in the order of 15%. I said it materially affects. They said, aha, but it doesn't detrimentally affect. And I say, that's your contract. Because you've all seen those clauses. They will tell you if it materially and detrimentally affects. And I said, I'm not relying on the contract, I'm relying on the statute. And an increase in size materially affects, and we're out of here. They didn't like it because they said, well, it's to your benefit. I don't care. It did materially affect, we were okay. So be clear, it's not the contract about material or detrimentally, it's the statute that says materially. The other one I had, and just to give you an indication of the process, worked through the owner's corp. Unit liability and unit entitlement had changed. They'd thrown in half a dozen things. I sent it out to my surveyor mate, who was known to say to me, I've never seen a final plan of subdivision that was anything like the original one from a surveyor's point of view. Unit liability and unit entitlement was changed to the tune of something in the order of 12%. I said that was material. Nice argument. If you just looked at the owner's corporation and the fees and the budget, 12% change, I think significant. You've got the comments elsewhere, 5%, Nathan talking about variations in areas and changes to boundaries. 5% has been rumbling around as a reasonable change. 10 or 12% change in owner's corporation liability in entitlement, I thought was enough to get us out. When we factored that back in, as they did, as you would expect, they said, well, it's that of owner's corporation unit entitlement liability, but if you look at the rates and the charges and the land tax and the this and the that, it's something in the order of 5.4%. And I said, I don't care, it's over 5, we're out of here. Now, we negotiated that one. No, we walked away, it wasn't too bad. So the second sort of major area in terms of law that you need to be aware of is the current issue about the right to extend. So this is basically Clifford's case and Bonji saying, look, if it's your standard form, 3 or 4 year old off the plan, they are going to say, we have the right to vary the date on which we settle to any date we like, and we'll tell you. And the answer is, Bonji just said, look, that's not good enough. If that's what it says, it doesn't comply, and you're entitled to walk. And I don't have any doubt that the developers regard that as good law, and the Court of Appeal has now said Bonji got it right. That's a fairly simple one. The contract can specify the 18 months as per the sale of land and or any other period. And the way Bonji worked it out was a clause which says the vendor can extend it to 3 years or such other period from time to time as the vendor may specify, didn't comply. It's a nice argument because the question then became, well, it specifies that it'll be this period or such other period as the vendor may, in his discretion, specify. And Bonji just said, look, that pushes the burden back onto a purchaser. You're organised to pay, you're told 2 years, you're told 3 years, you're told 4 years. If it's specified, you're gone. But if they can change it and extend it because there's a strike, they can't find the materials, they can't do this, they can't do that, then they can specify some other period. Why not? And that is a period specified. And Bonji just said, no, the right to vary it won't work. If you're past anything that they have specified, they don't get another crack at it. What I've seen, and what I warn you about, is they send out letters saying, we're now due to settle at such and such, we've had a delay, they can't do anything about it except try and protect their back. Here's an agreement pursuant to which the contract is varied to specify that date. So they try not to rely on the vendor saying, I'll do this and this is the new specified date. They try and get the purchaser to agree to an amendment to the contract. Didn't go through the solicitors in the particular case that I was looking at. And it was signed and popped back with a bundle of other stuff. Might have been tucked behind 4 years down the track. We can't have the Mealy dishwasher and we can't have the such and such thingy-bob or the Guggenor stovetop or something. That model's no longer available. So we're tinkering with this and we're tinkering with that. So just sign that and sign that and sign that, plus change the date. Haven't seen that argued yet, but it's significantly different and wouldn't necessarily be a Clifford case issue if by agreement both parties come to a new specified contract date and the contract now says the new agreed date. So they're out there. Don't know how many developers I'm talking to, but by and large I'm on the purchaser side of the deal because that's where the fights are. It's a bit of spy versus spy. Do this, well, we'll do that. Do this, we'll do that. That's what's currently happening. I've talked about 2 minutes. I'd rather stop now and just ask for some questions, preferably have them directed to Bill, but I'm happy to try and field what I can. I'll be bold, I won't make this a question to Bill. I read Bill's paper and Bill is always very precise in his words. I must say I agree with everything he said, the analysis and the final outcome. I was going to throw him a question, but I won't. I'll perhaps give my own answer to the question. My view is, if in doubt, serve the notice. Unless there's a real downside, unless the 14 days will worry you, or if you're going to serve an invalid notice and there's an issue about that, my inclination is serve the notice. Where's the downside? 14 days won't matter. But I think Bill's analysis is entirely right, and I was going to ask him what his answer to that question would be. If you were trying to do it, would you rely on the principle or not? I wouldn't. I'd serve the notice. A minute left for questions? Oh, plenty of time. Okay. Oh, thanks, Michael.
Unless we want to get to work in a hurry, Mitch. No.
Lindsay.
No, I'm sorry, I have to leave.
Oh, you're going. All right. No question. Thank you, Lindsay. Goodbye.
Hi, I just have a question about what you just finished on with the extension of the contract dates. Where does that leave purchasers in the sense that if you've got a contract that says the registration date is X and the vendor can extend that by no specified date, does that mean that that extension is invalid and unenforceable, or can the purchaser walk away from the whole contract?
Walk away from the whole contract. The rights under the Sale of Land Act concerning the time specified. So the section says it must, in order to comply, because it's a prescribed contract off the plan, it must have a period specified. If it doesn't have a period specified, it doesn't comply and the purchaser is entitled to walk. The Clifford case was based on the proposition that it initially said 18 months, but it could be extended to 3 years. They did have the extension to 3 years, and that's typical, isn't it? 18 months, 3 years, twice the time. But after 3 years, they tried to extend it for a further period, and the purchaser then said, I'm out of here. And the argument was the 3 years met or not? But there's no, it's all or nothing, and by and large, if they have the right to, if it's specified and they come in within the specified, no issue. If it's amended, then if they rely on the contract to make the amendment to a revised place, then by and large you can say no. So if you come in and they've said there's an extension, then you may well be able to say thank you and goodbye.
But what if the extension is specific, so you had to say 36
Linda.
months?
What happens if the extension is specified? So you have, say, 36 months plus 6 months for another 6 months maximum for unforeseeable delays or delays that are outside your control, because you do have specific times. You've got the 36 plus another 6. Will that comply?
No. 9AE subsection 2 says it's a statutory provision. If the plan isn't registered within 18 months of the date, so you've got 18 months from whatever you signed, that's sort of what I refer to as standard specified, or if the contract specifies another date.
So only one
or
date.
If the contract specifies another period before the end of that period, and that's what came undone. They in fact did specify a 3-year, and it was then proposed to be extended for another, I think in Clifford's case, another year. They just were running behind, there were a whole lot of problems. The answer was no, because it then says the purchaser may at any time before the expiration of that period, so it's the 18 months, or the period specified in the contract, and if the contract says 3 years, 3 years is okay, but any change to that 3 years, no. And it's an all or nothing, because it says the purchaser may at any time after the expiration of that period, but before the plan is so registered. Before the plan is registered. If it's looming and they've already extended, get in, because I have found instances where we're 2 weeks after the plan's registered and we don't have the money, we can't settle, and you go, God, if I'd only got it a month earlier, we'd be out of here walking, laughing. But once it's registered, your statutory rights, some of those statutory rights, so it's 9AA or 9AB and then 9AE. Watch it.
Back with the question on the deposit bonds and bank guarantees. So is the position right that if the purchaser pays a cash deposit, but the clause in the contract deals with deposit bonds and bank guarantees offends the Act, purchaser can still walk away?
No, the experience I've had in the clause said the fact that you could pay by deposit bond doesn't mean there's a necessary breach of the Act. So if you've chosen the straight deposit course, then I don't think that you have those rights. Perhaps it might be helpful if I say I have struck a situation where you do a simple holding deposit in cash, but you have the right to then replace it with a deposit bond. If you did then replace it with a deposit bond, and then the deposit bond provisions are as they were in Everest, you will be able to walk. So I've not struck one where someone said, I've paid cash on the knocker, it's held in the normal regime and it's subject to the Section 27 releases and all that stuff, and then said, but I could have done it the other way and the contract isn't right. I suppose there is an argument the contract does provide for that, but it's, I haven't struck one where someone's been bold enough to get away with that. I have struck one where there's a preliminary cash contract, replaced, go off to the bank, 7 days later, do it with a deposit bond, which takes up the cash payment, and then it's sitting there with a deposit bond. It normally doesn't come up until, you forget about that, and 2 years later, you can't get your finance, the bank lets you down, the price isn't what you hoped, it's a nightmare and you're screaming. Well, if you pay by deposit bond, I can tell you now you'll walk and you get your money back so long as you get in before they register it. All done? Thank you.
I might just make a comment, a further comment, sort of exercising the same right to comment on Mitch's paper that he exercised on mine. My reading of the Everest case is that it is what the clause says that's the problem, not what happens in fact. So if the clause says, and the problem in the Mendoza contract was that the clause said that the deposit bond monies could be paid to the vendor direct. It wasn't that the deposit bond said that, it was that the clause said that, and that offended the provision applying to prescribed contracts. And it was a very, very reluctant conclusion because it's a very technical reason to give a purchaser an out of an otherwise unremarkable commercial transaction. But as reluctant as he was, Justice Hargrave felt that the legislation required it. So I'm not sure that I would draw the same conclusion as Mitch if you actually choose to pay the money by cash, if the clause provides that you could have paid it by deposit bond and that clause breaches the Act. But that wasn't precisely the facts in Mendoza, so we'll just have to wait and see, I suppose.
Would you also just say that the stop on the waiver not being applicable to statute, like Hargrave said? So just saying that.
Yeah, well, sorry, if you want to, because I'm not quite sure the point you want to make.
No. Waiver and estoppel don't apply in regard to the...
Sorry. The other aspect in that case was Hargrave was called upon to deal with a possibility that someone had conducted themselves, the purchaser conducted themselves in such a way that they'd either waived or stopped their rights to rely on that. And when Bill says Hargrave came to it reluctantly, he did. He just said, look, I'm sorry, the statute says this, there has been conduct, but my reading of the appropriate principles is the statutory rights can't be overcome by any waiver, conduct or estoppel, so that I can't give the relief that I would otherwise be thinking of. So Bill's comment, of course, is as usual exactly right. He very much read the terms of the contract and said it doesn't comply because the deposit bond could go out that way. The point I'm making, I think, is that on that occasion, that it was a payment by deposit bond. I'm not sure what the position... Well, on Bill's reading, I can understand that. I've just never had it where someone had paid cash and then tried to rely on a deposit bond principle that says, well, the contract's in breach. Good argument. Let me know when it comes up.